What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. So today, I just want to do a supplemental video to the Mars Argo versus Poppy lawsuit. I've gotten lots of interactive feedback from people on both the comment sections on the videos as well as on Twitter, and in some other discussions as well. And I want to clarify some things, but let me quickly preface with something. I intend to do ongoing coverage of this case, as well as some of the other cases, and you'll kind of see how these things run. If you're not familiar with court, you'll get a lot of stuff really quickly as documents come out and a bunch of arguments are made, and then we'll hear nothing for like a month, and then a lot of stuff will happen, and then there will be nothing for a long period of time. So I plan on following this case as it develops, and one of the upcoming videos that's been requested in the comments, and I think it will be a good exercise, will be I will play as Argo's advocate or attorney and talk about what I think should be done to make the case stronger, or what kind of arguments can be made on her behalf. Now, if you watched my full analysis video, you may come across you may come out with the impression that I'm in favor of Poppy in particular. I don't favor either of them. I don't care. No offense. If you like them, that's great. They're not my, I'm not fans of either of them. I don't have a vested interest, but, you know, my goal in the first video was to point out a lot of the issues with the claims. And I stand by them, for the most part. You know, my opinion is subject to change as I get new information, and people are certainly sending me things, and I really appreciate that. And I like to review this stuff and round out my position. So I will be doing a video in the near future on a more favorable towards Mars Argo video, and what kind of things are strong in her claim and stuff like that, and maybe things that I think they might have left out, and what may be coming up. And that'll involve me doing a little more research into the specific things, because I will stand by my assertion that I think the complaint as written is weak, and that's kind of risky. And there are people pointing out that there's some certain comparisons that can be made that I don't recall reading in the suit or in the complaint here. And your complaint is your one chance to tell the story to the court, because if you don't do it well enough, then you lose on either dismissal or you can lose on summary judgment. And if that happens, you lose and you never get to tell the rest of your story. So complaints can sometimes be amended and other things, so that this isn't the end of the road, but I do think there are problems with this complaint. But certainly send me, you know, information, or you know, talk to me on Twitter or whatever. I'd be happy to look at things that you guys think are evidence of copyright infringement and talk about whether I think they're copyright infringement or not. Happy to do that. So this is interesting to me. And again, coming into this with very little knowledge about either of these artists. I appreciate that there are definitely communities built up around each of them, and you guys are going to know way more about their backstory than I am. Let me just add in one tiny bit of perspective that I'm bringing to the table. It's unlikely that the judge or any particular jury is going to be as versed in these two artists as any of you are. Okay? Especially if this is a judge. Judges are decades behind you, technologically speaking. Pop culture references are not strong with them, and they're not going to know it, and it will be hard for them to get it. Okay, so that's one thing to bear in mind, and that's part of what makes this case so complicated, and any of these cases involving technology, new types of media, new forms of entertainment such as YouTube, is that the courts aren't good at new things, they're good at old things. So on to this. So I really want to address one major thing that's been brought up, and that is a comparison. It's come up a couple times in the comments, and I've seen it elsewhere, but that is trying to compare Argo to Bette Midler and Tom Waits. Okay? Not artistically, but in a legal sense. There's a case, a Ninth Circuit Court of Appeals case, so that's a circuit that California's in, and that this federal court, that this case is brought in, so it will be authoritative if it's referenced and if it's used. I think they'll try and use it, but I'm going to talk about that in just a second, okay? And that's Midler versus Ford Motor Company. Some background on Midler versus Ford Motor Company. Ford Motor Company acquired the license to use a Bette Midler song, okay? But they wanted to hire Bette Midler. They wanted to hire original artists for a lot of different songs that they had picked up. They were trying to revitalize some older music, and kind of bring in a certain crowd who would find that music nostalgic. So they could not hire Bette Midler. She wouldn't do it. So what they did was they hired one of her backup singers, and they instructed this backup singer to sing the song in the way that Bette Midler would sing it, and to try and sound as much like her as possible. And a lot of people told the backup singer that the recording from the commercial was identical, was the same. You know, they thought it was Bette Midler, and there was some confusion there. Same thing with Waits. I think it was Tom Waits, right? Similar sort of issue where they acquired the license to his song, and then they found someone to sound like him because they wanted the sound to be like him, and the idea was this is causing confusion, okay? So some people have brought this up saying, arguing against me when I say that you can't own your voice, you can't own your image, your persona. They're saying that you can because of these cases, all right? When I say you can't own it, I mean you can't own a copyright on it. Like, I obviously own my image and persona. It's me, it's mine. It's my expression. However, I can't copyright those things. I can copyright a particular work, like the video that you're watching right now will be a copyrighted work. If you were to reproduce this video without my permission and outside of the grounds of fair use, that would be a violation of my copyright, okay? And that will necessarily involve my image, my persona, my likeness, and my voice. All of those things are involved in making this thing. But I won't own the copyright to those things. I'll own the copyright to this video. Okay, so then if you are just merely copying my style, the style that is me, or I shouldn't say copying, but if you're doing something similar, I'm not going to have a copyright claim. I may have a different claim. So let's look at the two claims that are in question here. Count one is copyright infringement. All right. And they go through and talk about the copyright infringement. Count two is a common law right to publicity. And this is where the Waits and Midler claim come in. But there's some really important distinctions here. But what I'm explaining this in one way, but let the court, the Ninth Circuit Court of Appeals, explain it better. And this is, actually, this wasn't Ninth Circuit Court of Appeals. Who was this? This is the District Court of California. Okay, the Central District, California. So not quite the same district that they're bringing this in San Francisco, but it's very similar. Okay, and Ninth Circuit's going to be authoritative. But this is Laws versus Sony Music Entertainment Incorporated, okay? Let me let them talk about this issue with Bette Midler and Waits. The Ninth Circuit has held the use of a person's voice does not fall under copyright protection, that the state law claims are not preempted. We'll get to that state law claims in just a minute. See Midler versus Ford Motor Company and Waits versus Frito-Lay. However, in those cases, the expropriator had imitated the person's voice without permission. Courts found that a person's voice is more personal than a work of authorship. That's why you can't own your voice in copyright. Copyright is something you create, not something that's intrinsic to you, okay? Both courts associated a person's voice with part of her identity. In neither case was the voice fixed in a work of authorship. In other identity cases, courts have found common law or state statutory claims are not preempted. Let's see. The court acknowledged that actors could bring a common law right of publicity action against defendants for using animatronic robots that bore some likeness to the actors. The court noted that actors do not lose the right to control the commercial exploitation of their likeness. Okay, here's where the hang-up is happening with Argo and Poppy. If you have a copyright claim, that's you copying an authored work. An image, a persona, a likeness, a feel about a character, those sorts of things are not copyrightable. Okay? You can't, I don't know how else to say it. You can't copyright those things, so you can't have a copyright infringement claim in those aspects. You may have copyright infringement in a particular work. One of the works cited here is where Argo is eating various foods, chips, gummy bears, pizza dippers, stuff like that. And then Poppy has a very similar looking video where she's drinking Monster Energy drinks and eating Doritos. And the line delivery and editing is very similar. And that's what's stated. I think it's paragraph 92. Okay. That would be a copyright type claim. If they determine that Poppy is copying this video, and there's some issues with stating outright that it's copyright. Okay. It might be, it might not be. But that's a type of copyright claim, saying she's taking my style and my image and this thing that I built up and this sort of aesthetic around my person. That is not the same thing, because Argo is not creating the things that she's wearing, right? Like if it were her designer line of clothing that she is designing, or she is acquiring the rights to the designs because she's hiring the designers to do it, that's a different story. That's not alleged in this case. If that's the case, they need to amend the complaint and do that. But saying I bought this skirt and this shirt and wore them together, and she bought a similar looking skirt and similar looking shirt and wore them together, that's not going to fly as a copyright claim. So then we get down to this common law right to publicity. So this is the idea that you own your image, your likeness, your name, all of those things. You own them in a different way than copyright, but they're yours, and someone cannot utilize those things without your consent to either enrich themselves or cause detriment to you. Typically, we see this where one person is one group is trying to make it look like a person endorses a product. For example, the Midler versus Ford Motor Company and Waits versus Frito-Lay. They imitated the voice of Bette Midler singing her song to make people think that Bette Midler's song and Bette Midler, by extension, is being used in sponsorship of the Ford vehicle. But Bette Midler wasn't sponsoring the Ford vehicle. She wasn't compensated for it, didn't want to do it, wasn't doing advertisements. Waits, same thing with Frito-Lay. Waits said he wouldn't do advertising ever again at the time that this commercial was recorded. He was not a fan of it. He didn't like doing advertising, called it a special kind of hell, okay? So he wouldn't do the ad. They found someone else to mimic his style, mimic his voice, and the idea was that it seems like Waits is the one doing the song and therefore endorsing the product, but that wasn't the case. Here, Argo has a big hurdle to overcome because they explicitly remove Mars Argo from the brand, right? They block her name on YouTube. They block her name on social media. If you mention Mars Argo, they will shut down any sort of conversation about that. They're not trying to associate Mars Argo with the Poppy Project actively. Now, I get it. I get it. Surreptitiously, they're trying to copy this style that was done. They're trying to link maybe psychologically to this thing that people liked in order to bring the fans over. Some fans may be confused. I get all of that, okay? I understand. But a common law right to publicity, publicity is the key word. We're trying to associate this specifically with a person for some sort of endorsement or advertisement of the product. This person likes my, or is in support of this thing. They're distancing themselves from Mars Argo, and every time they do that, they undermine very much this idea that there's a right to publicity. Also, while there are similarities between their delivery and the voice and stuff like that, unless they're trying to make it look like it's Mars Argo specifically, not someone who is mimicking Mars Argo or imitating Mars Argo, but they're trying to impersonate Mars Argo. They're trying to fool the viewer or listener into thinking that Poppy is Mars Argo. That's a common law right to publicity violation, where they're trying to associate Mars with the brand. Saying that they're borrowing her style or they're doing these things that she did already, that's a copyright issue, and those things might not be copyrightable. So these are the big hurdles with the claim. This is why Midler and Waits will not apply to the copyright issues. And they're going to undermine the publicity issues, because Midler and Waits, when they're talking about having their distinct voices, it's because when people are exposed to the ad that Midler, you know, Midler's Ford ad, or the Ford ad imitating Midler, and the Frito-Lay ad imitating Waits, when they're exposed to those things, they're thinking that the actual artist is involved, because we're talking about trying to impersonate. I said imitate, I mean impersonate. We're trying to become that person, trying to convey that person's image and likeness. Trying to allude to or reference someone or be derivative of something is not a publicity claim. It's just not. They're distinctly different. The copyright claim might be there in some aspects. I think they're really weak. And if we're talking about just the overall persona, image, and style, that's not copyrightable. Okay. So I hope this helps clarify things. I hope you will keep watching for updates in the future. The next video I plan on doing, in this case, is the Mars Argo advocacy one. So if you're mad at me about how I've been sticking up for Poppy, let's flip the script on that, and then a bunch of other people can be mad at me for how I stick up for Argo, and that's okay. We can discuss these things, but yeah. So I hope this helps kind of clarify why I don't think Waits or Midler's cases are going to play a major role in helping Argo. They may actually hurt her on this publicity claim because of just the differing facts in these cases. So thanks for watching, guys. Stay tuned. Hit like and subscribe if you want to follow along with this and all sorts of other lawsuits and legal issues that I cover. And if you have lawsuits and legal issues that you would like me to cover, check me out at patreon.com/lawsplaining. You can follow there. You can send me money if you want to send me money, and that's a good place to send me suggestions on content, and I'm very happy to engage with you and discuss things. Also, you can hit up any one of my social media things in the description. So thanks so much for watching. Y'all have a nice night.